In the current affairs bridge, we are moving to next scene, that is private property and the community's resources. The 9 Judge verdict on Article 39, Clause B. This is extends in the previous scenes on fundamental rights and the directive principles and chapter 4, scene number 10, basic structure. We now turn to the block this part has so far left untouched, that is fundamental rights and the directive principles. And we start with the heaviest artillery available, that is a 9 Judge constitution bench answering a question that had been pending since 1992, and the single most litigated fundamental rights versus DPSP fault line in the constitution history, that is private property under Article 39, Clause B. This is the 9 Judge verdict. So the question here is Article 39, Clause B directs the state to ensure that the ownership and the control of the material resources of the community are distributed to subserve the common good. And Article 31C shields laws giving effect to it from challenge under Articles 14 and Article 19. So everything turns on one phrase. Does material resources of the community include privately owned resources? That is the question actually here arise. Does material resources of the community include privately owned resources? For 4 decades, the field was dominated by Justice Krishna Iyer's expansive answer. That is, first in his minority opinion in Ranganatha Reddy 1977, later endorsed on Sanjeev Koke 1982, that everything private is potentially the communities acquirable for redistribution. The answer is Property Owners Association versus State of Maharashtra, 5th November 2024, a 9 Judge bench led by CJI D.Y. Chandrachudi. Then the majority held that not every privately owned resource automatically qualifies as a material resource of the community. Whether a given private resources falls within Article 39 Clause B is a context specific inquiry. The nature of the resource, its scarcity, the consequences of its concentration in private hands, and the considerations akin to the public trust doctrine all matter. So not every privately owned resources automatically qualifies as a material resource of the community. Whether a given private resource falls within Article 39 Clause B is a context specific. Is a context specific. Context specific inquiry. The nature of the resource, its scarcity, the consequences of its concentration in private hands, and considerations akin to the public trust doctrine all matters. Public trust considerations, the consequences of concentration. So the majority expressly declined to endorse the Krishna Iyer line, observing that it reflected a particular economic ideology of its era. It reflected its era's economic ideology on that time. And that the constitution, deliberately framed in broad terms, does not lock the country into any single economic doctrine. Economic policy is left to elected governments. Justice Nagaratna concurred in part while objecting to the majority's criticism of Justice Krishna Iyer, and Justice Dulia dissented. Knowing that internal disagreement exists is itself worth a line, because it shows the redistribution question remains philosophically contested even as the legal test is settled. Justice Nagaratna concurs, objecting to the criticism of Iyer. Dulia dissents, Justice Dulia dissents. The redistribution question stays physically contested, even as the legally settled. The second holding, easy to miss but doctrinally crucial, that is, the bench also resolved the long standing confusion over Article 31C's survival. After Keshavananda upheld 31C's protection for Article 39 Class B and Class C laws, and Minerva Mills struck down its 42nd Amendment expansion to all DPSPs, the status of the original unexpanded 31C was uncertain. Comes to the second holding, the original Article 31C survives to the extent upheld in the Keshavananda Bharati case. Laws genuinely under 39 Class B and Class C still shielded from Article 14 and Article 19. But only if the resource passes the new test, the shield survives, the doorway narrows. So the court confirmed it survives to the extent upheld in Keshavananda case. So laws genuinely giving effect to Article 39 Class B and Class C still receive protection from Article 14 and Article 19 challenge, but only if the resource genuinely qualifies under the new context specific test. Context specific test. Notice the elegant architecture here. The shield survives, but the doorway into the shield was narrowed with through content specific inquiry. So matter for why does this matter for your fundamental rights and DPSP framework? Why? Because it is modern chapter of the very story in previous part 1 traced from Champakam Dorairajan case through Golaknath, then Keshavananda Bharati and Minerva Mills. The pendulum between rights as limits on the state and directives as mandates to it. So Minerva Mills case gave you the harmony and balance doctrine. Property owners applies it to the redistribution question specifically. The DPSP is honored, but not by erasing the right to property. Now Article 300A. A reading one 1970s economic philosophy into the constitutional text. Comes to the answer writing part, the directive principles are a mandate for social transformation, not a license for expropriation. Discuss in the light of Supreme Court's 2024 interpretation of Article 39, Clause B. The answer traces the Krishna Iyer doctrine and its origin, states the new context specific test precisely, and then explains the 31C holding and its Keshavananda Minerva lineage, notes that concurrence and dissent to show the question's life philosophical edge, and closes on the harmonization theme, that is, the judgment neither weaponizes the DPSP against property nor neuters it. It demands a case by case public interest justification, which is exactly what balance mean in operation. That is why here context specific examination and a context specific inquiry is need of the hour. That is crucial. So this is the definitive fundamental rights and directive principle state policy authority of this cycle. A 9 judge bench, a 40-year-old doctrine revisited, and a clean two-part holding, that is 39 class B test and 31 C survival, that you should be able to state in two sentences flat. So this is regarding about private property and Article 39 class B, the 9 judge verdict, and answer writing practice. Then comes to the next scene, that is the Uniform Civil Code arrives. Uttarakhand operationalize Article 44. It extends part 1's directive principles scene and chapter 4 scene number 9 salient features, that is secular democratic republic, universal civil code. Uttarakhand operationalizes Article 44. For 75 years, Article 44 was the Constitution's most famous unredeemed promise, a directive principle cited in Shabano, in Sarla Mudgal, in Jan Vallamattom, always as judicial exhortation, never as enacted law. That changed in this cycle, and it changed at the state level, which itself the first analytical point to register what happened. On 27 2025, Uttarakhand brings the first state UCC into force, that is Uniform Civil Code into a force. A single statute, a single statute governing marriage, governing divorce, governing succession, and live-in relationships for all communities in the state, with a segment carve out, that is scheduled tribes are exempted. So the code prohibits polygamy. The code prohibits polygamy and practices such as iddat linked restrictions, and prescribes uniform prohibited degree rules for marriage, mandates registration of marriage, and most controversially makes registration of live-in relationships compulsory, backed by criminal penalties, with registrars empowered to inquire into the relationship's existence. So here the most controversial thing is makes registration of live-in relationships compulsory, backed by criminal penalties, with registrars empowered to inquire into the relationship's existence. Gujarat has since constituted a committee under retired Justice Ranjana Desai to draft its own, signaling that the state level route may become the pattern. So the constitutional contest was immediate. A batch of petitions before the Uttarakhand High Court challenges the code on strikingly familiar grounds, that is Article 25 and Article 26. And it that effectively expect extending Hindu marriages act concepts to Articles 14 and 15, and the genuinely new generation ground Article 21 privacy under Puttaswamy aimed the mandatory live-in registration regime, which petitioners argue converts an intimate personal choice into a state surveilled, criminally enforced disclosure. So comes to this part, a batch of petitions before the Uttarakhand High Court challenges the code on strikingly familiar grounds under Article 25 and 26. Under Article 25 and 26, petitioners argue the code overrides Muslim and Parsi customs and prohibited degrees, polygamy, and iddat, effectively extended Hindu Marriage Act concepts to all communities. And comes to the Articles 14 and 15, both the minority community objection and from the opposite direction. The question whether exempting scheduled tribes while covering everyone else a defensible classification. The batch of petitions, Article 25, 26, Article 14, and Article 15, and Article 21 privacy under Puttaswamy case aimed at the mandatory live-in registration regime, which petitioners argues converts an intimate personal choice into a state surveilled, criminally enforced disclosure. The state's defense is protective framing, like what registration legitimizes children of such relationships and secures maintenance rights deserted women. The matter remains pending before the High Court as of this revision. So once again present the constitutional questions as open, not answered. Now step back to the framework because this is where marks live. Article 44 is non-justiciable directive. No court can compel its enactment. Yet personal law sits in the concurrent list, entry number 5. So which is what makes a state level UCC constitutionally possible in the first place. And simultaneously creates the paradox worth naming in any answer like this: a uniform civil code implemented state by state produces uniformity within a state, but a new patchwork across the country, arguably the opposite of what Article 44's framers imagined. And the litigation replaced the oldest tension in the syllabus in modern dress, that is a directive principle, Article 44, being implemented in a way that fundamental rights claims, Articles 25, 26, 21, and 14, are now deployed to resist. The Champakam's question running in reverse. So comes to the answer writing part. The implementation of a uniform civil code at the state level raises as many constitutional questions as it answers. Examines with reference to the Uttarakhand Uniform Civil Code. Answer situates Article 44 in the DPSP scheme and its judicial history. Then explains the concurrent list basis for state action and the resulting patchwork paradox. Then organizes the pending challenges by constitutional ground, that is religious freedom, equality and the tribal exemption, and privacy over living registration, then present the states protective, rationally, fairly, and closely by noting the High Court proceedings are pending. So the court's validity is an open question that any honest answer must live upon. So Article 44 has finally moved from sermon to statute, and the moment it did, it collided with Articles 25, Article 26, Article 21, and Article 14. Exactly as every fundamental right and a directive principle state policy framework you carry would predict. So you have to know the code's key features, the four grounds of challenge, and the pending status in that order. The four grounds of challenges here: Article 25, 26, 14, 15, and 21. So then we are moving to, this is all about UCC, that is Uniform Civil Code. And we are moving to next scene, that is right to digital access. Right to digital access. This is the Article 12's newest frontier. So it extends from Part 1 fundamental rights scenes, the Article 21 expansion line from Maneka Gandhi onward. So comes to the part, one last rights scene, and it ends its place for two reasons. It is the cycle's cleanest example of Article 21's evolutionary method still at work, and it is the cycle's best illustration of DPSPs being used to expand rights rather than compete with them. The constructive half of the fundamental rights and DPSP relationship that students chronically forget to cite. So what happened? We are going to learn. So what happened on 30th April, 30 April 25, in Pragya Prasoon versus Union of India, heard with Amar Jain versus Union of India, a bench of justices J.B. Pardiwala and R. Mahadevan held that inclusive and meaningful digital access to e-governance and welfare delivery systems is an intrinsic component of the right to life and liberty under Article 21. Here, judgment authored by Justice Mahadevan. So the petitioners tell you why acid attack survivors with facial disfigurement and fully blind advocate who could not complete digital KYC because the process demanded blinking, selfies, facial alignment, and short window OTPs. In an era where banking, welfare, education, and governance are accessed digitally, the court reasoned exclusion from digital systems nullifies the practical enjoyment of every other right. So, digital inclusion is a constitutional imperative, not a discretionary policy choice. So, it issued 20 directions to make the eKYC process universally accessible, invoking the rights of persons with disabilities Act 2016. Now, the framework point that lifts this from current affairs to constitutional law. What is the framework? Why we are going to discuss this for Mains 2026? The court anchored the holding not in Article 21 alone, but in Articles 14, 15, and 21, read with Article 38, a directive principle invoking the principle of substantive equality. The state's obligation is not merely to refrain from excluding, but affirmatively design systems the most vulnerable can use. That is the harmonious fundamental right and DPSP reading directives informing the content of rights, operating exactly as Minerva Mills envisaged. And it stands as the constructive counterpart to the collision scenes you have just studied in scenes 34 and 35. It also extends the Article 21 expansion lineage called Maneka Gandhi, Maneka Gandhi's fair, just, reasonable procedure that derived rights to livelihood, shelter, privacy, and most recently, the 2024 recognition of a right against the adverse effects of climate change. With the digital access as the newest entry and the same interpretive method underneath, Article 21 read in light of contemporary conditions of a dignified life. So notice finally the quite thematic rhyme with scene 27. What is that? SIR was about citizens excluded by documentary demands. This case is about citizens excluded by digital design. So both raise the same governance era question. When the state's delivery machinery presumes capacities a citizen may lack, whose button is the cap? When the state's delivery machinery presumes capacities a citizen may lack, whose burden is the gap? An answer that connects the two shows exactly the cross scene thinking the script exists to train. One adjacent right spec belongs in the scene because without it, this part's fundamental rights coverage would be all Article 21 and no Article 19. And UPSC will not be so narrow. In Imran Pratap Garhi versus State of Gujarat, March 2025, a bench of justices A.S. Oka and Ujjal Buyan quashed an FIR registered against a sitting MP over a poem shared online and used the occasion to restate free speech first principles. What are that? What are those free speech first principles? The effect of spoken or written words must be judged by the standard of reasonable, strong minded individuals, not of those with weak or insecure minds. The police, before registering an FIR over expression, are themselves bound by Article 19, Clause 1, Subclause A, and must abide by the Constitution. And literature, poetry, satire, and art are what make human life meaningful. 75 years into the Republic, courts must lead in protecting, not policing, expression. For one line for your answers, this is the same expansive interpretive method you have just seen applied to Article 21, now applied to Article 19. The cycle's cleanest reminder that the dignity Article 21 protects includes the voice of Article 19 guarantees. So, what is this exactly? The right to digital access, Article 21's newest form. What is the framework here? What is the lineage here? What is the scene rhyme with scene 27? And then what is Article 19 peg? These are all discussed in this section regarding the right to digital access. Comes to the answer writing part. In the digital age, the right to life under Article 21 includes the right to digital access. Examine the statement in the light of recent Supreme Court jurisprudence. Comes to the answer part. Answer states the Pragya Prasoon or Amar Jain holding and its facts, explains the substantive equality reasoning, and the Article 38 anchor as model of FR and DSP harmony, then situates the Judgment in the Article 21 expansion lineage from Maneka Gandhi onward. Notes implementation as the real test. Then 20 directions are only as good as their compliance. And then closing, closing lines and closes on the digital divide caution with recognizing the right is the beginning of inclusion, not its achievement. So one case three uses here an Article 21 expansion authority, a DPSP as interpretive aid illustration, and a welfare state accessibility critique all form a single precisely dated quotable judgment. So this is all about right to digital access, Article 21's newest frontier. So comes to the one case three uses pattern, an Article 21 expansion authority, a DPSP as interpretive method, interpretive aid illustration, and welfare state accessibility critique all form a single precisely dated quotable judgment. Comes to the next scene, that is who appoints the judges, the Collegium debate round 2. It extends chapter 8 scene 14 the judiciary and pairs with scene 30. What is scene 30 gave you accountability crisis? This scene gives you what that crisis reignited. Because within days of the Verma cash discovery, the oldest structural debate in the judiciary chapter roared back to life. What is that? That is who should appoint India's judges. The framework you carry from scene 14 stated in one breath. What is that? Articles 124 and Article 217 say consultation. Consultation. The second judge's case 1993 converted consultation into concurrence and created the collegium. The third judge's case 1998 fixed its composition. Parliament's answer, the 99th Amendment and the NJSC Act 2014 passed near unanimously and ratified 16 states, was struck down 4:1 in 2015 as violating judicial independence. A basic structure component, that is, with Justice Chalameshwar's dissent becoming the most cited minority opinion of the era. What is Justice Chalameshwar dissent? What he said, transparency is the greatest enemy of arbitrariness. Transparency is the greatest enemy of arbitrariness. And the memorandum of procedure, the 2015 judgment itself directed as a consolation reform, remains unfinalized more than a decade later. Deadlocked principally over the government's demand for a national security veto. Now, the current round, we are discussing the Verma episode handed the NJAC camp its most potent argument in years. For who? For supporting NJAC camp. So, a closed appointments system producing a closed accountability system. And the political response was immediate. Political response was immediate and came from the top. The then Rajya Sabha chairman told the House the NJAC had been a visionary step endorsed by Parliament, framed the country as standing at a crossroads between a parliamentary enactment sanctioned, sanctified by presidential assent and a judicial order, and moved to convene all party consultations on the collegium. Read that framing carefully because it is basic structure politics in its purest form. The claim that democratic legitimacy should outweigh a 4 is to 1 judicial verdict. Precisely the tension. Scene 10 taught you the doctrine exists to manage. What is democratic legitimacy here? Near unanimous parliament plus 16 state ratification. So the judiciary's answer was not doctrinal but behavioral. Internal reform as a preemptive defense of the collegium. Three moves, all citable with dates. What happened? First, on 1st April 2025, a full court resolution of the Supreme Court committed judges to publicly declaring their assets on the court's website through compliance tells its own story. Barely 12% of sitting High Court judges nationwide had disclosed by mid April 2025, with 18 High Courts publishing nothing at all. Comes to the second. In May 2025, the court published unprecedented appointment data, including the disclosure that of a 221 recent High Court recommendations, around 14 candidates were related to sitting or retired judges. A transparency move aimed squarely at the uncle judges nepotism critic. And third one, the Collegium has increasingly recorded and published reasons and conducted candidates interaction. Set against this, over 250 court vacancies persisting as of early 2026 against a sanction strength of roughly 1114 with both sides. Collegium delay and government sitting on recommendations. So sharing blame in a standoff, no court order has resolved. The analytical core of your answer is 2 by 2. You can draw in the margin. The Collegium protects independence but lacks accountability. This is most important. The NJAC offered accountability, but on the 2015 majority's reading threatened independence. So every reform proposal, a revised NJAC with judicial primacy guaranteed, a binding MOP with timelines for both sides, an independent secretariat, diversity mandates, is an attempt to escape one quadrant without falling into the other. And the freshest twist is on this part has already given you after scene 30. The strongest argument is no longer transparency in the abstract. It is that appointments and accountability are one system, and reforming either alone reforms neither. So comes to the answer writing part. Recent controversies have revived the debate on the method of judicial appointments in India. Critically examine whether the answer lies in reviving the NJAC or in reforming the collegium from within. So a high scoring answer, first and foremost, what do traces the judges cases and the NJAC verdict compactly, presents the 2025 reveal with its democratic legitimacy framing, credits the judiciary's internal reforms and asset declaration, published data, recorded reasons, while citing the weak compliance figures as evidence of self-regulation's limits. Then comes to the other thing, notes on MOP deadlock and the vacancy crisis as the practical cost of the stalemate, and closes with the balanced institutional design answer rather than a partisan one. Independence and accountability are not rivals but co-requirements. Independence and accountability are not rivals but co-requirements. And any durable model must guarantee both structurally, not rhetorically. So this is the evergreen judiciary debate wearing the cycle's cloths. No, the 2025 begs precisely. Because the framework itself you have carried since scene 20, scene 14. So the 0 hour crossroads framing, the 1st April full court resolution, the compliance gap, the May disclosure data, the unfinalized MOP. So this is the way you have to project underwriting an answer. Then we are moving to next scene, that is the judge who spoke, that is extrajudicial speech and the stalled removal motion. This is also extends from chapter 8 scene 14, that judiciary and completes the accountability with the scenes 30 37. This is one more judiciary scene and it earns its place. Why? Because it exposes an accountability gap different from and complementary to the one Varma exposed. And Varma showed a judge can escape a verdict by resigning at the end of the process. This scene shows a removal motion can die before the process even begins. What is the trigger? In December 2024, Justice Shekhar Kumar Yadav, a sitting judge of the Allahabad High Court, spoke at an event organized by the legal cell of Vishwa Hindu Parishad, where he remarked that the country would function according to the wishes of its majority, alongside language widely reported as a slur against Muslims. The criticism was immediate and cut to the constitutional core. A sitting judge at an event of an avowedly ideological organization making majoritarian remarks implicating the impartiality that Articles 14 and the secular character of the state presuppose, and the restatement of values of judicial life 1997, which enjoins judges to avoid any act, including public utterances, that erodes the perception of impartiality. The two track response here, and where each track was went. The track one in house. The Supreme Court took note, sought a report from Allahabad High Court, and the judge was called before the Collegium. But the in-house track produced no public outcome, and Justice Yadav continued in office with a judicial work. Comes to the track 2, parliamentary. On 13 December 2024, 55 Rajya Sabha MPs submitted a notice of motion for his removal under the Judges Inquiry Act 1968, comfortably above the 50 signature threshold for the upper house. And then nothing. And then nothing. The motion has remained stalled at the very first gate. What happened? Signature verification before the Rajya Sabha Secretariat with only 45 of the 55 signatures verified. Months later, a duplicated signature raising forgery allegations. And critically, no decision by the chairman to admit or refuse the motion, and therefore no inquiry committee constituted. As of this revision, now place this beside scene 30 because the contrast in the entire analytical payoff. In Verma's case, the Lok Sabha Speaker admitted the motion and constituted the statutory committee within weeks, and the Supreme Court dismissing Verma's challenge to that admission affirmed the presiding officer's authority to act. In Yadav's case, the equivalent motion has sat unprocessed for well over a year. Same statute, same mechanism, radically different velocity. And the difference lies in feature of the Judges Inquiry Act that students routinely miss. Admission of a removal motion itself a discretionary act of the presiding officer. a political gatekeeping stage before any judicial style inquiry begins. So the removal mechanism has soft points at both ends. A motion can be stalled at entry in Yadav's case, justice, and verdict can be forestalled at exit by registration, Justice Verma case. Between those two doors, the deliberately difficult removal process in Scene 14 framework praised as an independent safeguard starts to look like something else as well. A process that in practice has never once run to completion against a judge in the Republic's history. So the deeper debate this opens, and UPSC could ask it directly, is the judicial speech question itself. Where is the line between a judge's freedom of expression as a citizen and the discipline of the robe? The traditional position is that judges speak through judgments. The 1997 restatement operationalizes it, but there is no binding, enforceable code with guaranteed and graduated sanctions between the extremes of nothing and removal. No censure, no suspension, no public reprimand. That missing middle is the reform space. Proposals include a statutory judicial conduct commission, graduated sanctions short of removal, and a time bound duty on presiding officers to decide admission of removal motions. So, and a second gate question surfaced in the same window: who outside the judiciary itself may even investigate a sitting judge? In January 2025, the Lokpal held that High Court judges fall within its jurisdiction under the Lokpal and Lokayuktas Act 2013, reading a High Court as body established by an act of parliament. Within weeks, the Supreme Court took sumoto cognizance, stayed the order, describe, describing it as something very disturbing, and subsequently held that judges of the Constitutional Courts lies outside the Lokpal's remit, since high courts are creations of the constitution, not unparliamentary statute. So doctrinally tidy as an independence holding, it also deepens the very gap this scene is mapping. With the Lokpal excluded, the in-house route toothless, and the removal process never once completed till now. There is today no external body that can hold a sitting judge of constitutional court to account short of parliament itself, which as Ado shows justice. So may simply never open the gate. One adjacent conduct debate belongs in this scene because UPSC could bolt it onto any accountability question. Comes to the post-retirement appointments. The Constitution bars retired judges from practicing Article 124, Class 7 and 220. But it is silent on their accepting government posts, governorships, Rajya Sabha nominations, tribunal chairmanships, and every such acceptance shortly after retirement feeds the perception that judgment delivered in office might be shaped by prospects after it. So compare the constitutional design elsewhere. The CAG is expressly ineligible for further government office under Article 148 Clause 4, and UPSC member face similar bars at Article 13 319. The judiciary alone lacks an equivalent, and the standard reform proposal is a statutory cooling off period of around 2 years. The debate's freshest peg is a gesture, not a law. CJI BR Gawai publicly declared he would accept no post-retirement government assignment. Accountability by personal example. which is precisely the problem. Since a norm that depends on individual virtue is not an institutional safeguard. That one line is personal virtue is not institutional design. Is a closer worth memorizing. So this is all regarding about Justice Shekhar Yadav case in Enquiry Track 1 in-house and Enquiry Track 2 parliamentary. Then what is contrast with the Verma case, and then what is the adjacent gate, and then comes to new thing post-retirement gap. Practice barred for CAG, UPSC. Personal virtue is not institutional design. Comes to the answer writing, but the mechanism for judicial accountability in India oscillate between the ineffective and the impossible. Discuss with reference to recent instances involving judges of the higher judiciary. The answer should be like this. Answer uses Yadav and Verma's, Justice Yadav and Justice Verma as paid case studies. Entry gate failure and exit gate failure. Explain the in-house procedures lack of teeth and the 1968 Act's discretionary admission stage, and invokes the 1997 restatement and the absent middle tier of sanctions, concedes the independence rationale for a difficult removal process, and then closes with the graduated sanctions reform argument like accountability fails not because removal is hard, but because removal is the only tool. So comes to the summarized part. Scenes 30, 37, and 38 are one story told these three ways: conduct, appointments, and speech, and together they hand you a complete, currently precisely dated answer to the single most predictable judiciary question of 2026. Independence has been secured, accountability remains under construction. So this is all regarding about the judge who spoke, speech, the stalled removal motion. Then comes to the next scene, that is the working judiciary, pendency, digitization, and the draft AI regulations. This is also extends from chapter 8, scene 14, the judiciary, and links forward to GS3's technology and the governance themes. This is comes to every judiciary scene so far has been about power, like who appoints, who removes, who overreaches, etc. But this final is about function. What is that function? Whether the machine actually delivers justice at the speed of a rights bearing citizen is entitled to. Whether the machine actually delivers justice at speed a rights bearing citizen is entitled to. UPSC increasingly frames the judiciary through this efficiency lens. And the constitutional hook is one you already carry. What is that? The right to speedy trial has been part of Article 21 since Hussein Ara cartoon. So delay is not an administrative inconvenience. It is a rights violation at a scale. So the scale in three citable figures. What is that? What are the citable figures? What are three citable figures? But that is total pendency across the judiciary has crossed the 4.5 crore mark. High courts are running more than 250 judges short of a sanctioned strength of roughly 1114 as of early 2026. Short of 250 judges. Pendency cases 4.5 crore mark. And India's judge to population ratio remains around 21 per million against the 50th Law Commission's 120th report recommended 4 decades ago. The analytical framing worth using here, the reform conversation has shifted from asset creation to more courtrooms, more posts, to justice management. Then case flow rules, differentiated case tracks, and data driven docket administration. That shift is precisely what the designation, what the digitization program is for the infrastructure. Comes to the e-courts phase. E-courts phase 3 approved 2023 with an outlay over 7,000 crores, aims at fully digital paperless courts, cloud-based case records, and the piece to name in any answer. The National Judicial Data Grid, which puts live pendency data for every court in the country in the public domain. Register what the NJDG, that is National Judicial Data Grid, actually is constitutionally an accountability instrument. For the first time, judiciary's performance is externally continuously visible, which connects these scenes straight back to the triptych of scenes 30, 37, and 38. Transparency of conduct, of appointments, and now of output comes to this. But carry the counterweight too and link it into the scene 36. The same digital turn that promises efficiency raises the digital justice divide. If e-filing, if e-filing and virtual hearings presume connectivity, devices, and literacy that rural and poor litigants lack. The Amarjain logic applies with full force. A digitized court system that excludes is an Article 21 problem of its own making. Now, the newest development is and get its status exactly right. How? On 3rd June 2026, the Supreme Court's AA committee published the draft. What is the draft? Regulations for use of artificial intelligence in courts 2026. Draft released, public comment for until 20 June 2026. Not in force as the not in force as of this revision. It is the first attempt at a uniform judiciary wide AI governance framework covering the Supreme Court, High Courts, tribunals, and statutory adjudicatory bodies, and it follows a period of fragmented practice. The Kerala High Court issued the first High Court AI policy for the district judiciary in July 2025, confining AI to administrative, research, and translation assistance, never judicial reasoning with disciplinary consequences. With Gujarat following, even as courts confronted actual AI hallucinations incidents, including fake citations in filings before the Supreme Court itself. So, know the draft's architecture in 5 words and 4 rules. 5 foundational principles: what? Human primacy, transparency, accountability, data protection, judicial independence. Comes to the 4 operative rules. Worth quoting, those are: AI may assist case management, scheduling, legal research, citation, verification, transcription, translation with human verification. But AI shall not adjudicate or influence judicial outcomes. Predictive risk scoring is barred. Opaque, non-explainable systems are prohibited in matters affecting rights of personal liberty. And advocates must disclose AI assistance in any document filed. This is even a doctrinal grace note you can deploy. The draft expressly directs judges to the Bangalore Principles of Judicial Conduct 2002 when addressing AI issues, the International Judicial Ethics Framework meeting the newest technology in one citable sentence. The proposed institutional design, a permanent apex body at the Supreme Court with subordinate AI committees, and also hands you ready separation powers observation. What are the observation of separation powers? The judiciary regulating its own technological transformation for better independence, and for worse, the self-regulation concerns in 30 and 70. 37 have already taught you to articulate. So comes to the answer writing part. Technology can be a means to justice, but never its substitute. Evaluate India's judicial digitization efforts and the proposed framework for the use of artificial intelligence in courts. This is the question. Answer opens with pendency as an Article 21 problem, then present C court phase 3 and the national judicial data grid as the efficiency and transparency response, then flags the digital justice divide with the scene 36 cross references, then states with June 2026 draft AI regulations precisely, then draft status, human primacy principle, the assist but never educated line, then mandatory disclosure, and closes on the quotable synthesis the draft itself embodies. That is, AI in courts must remain in the framework own philosophy, strictly subservient to human judgment. So three layers, one scene. The problem, what is the problem here? Pendency as a rights crisis. Then comes to the infrastructure. What is the infrastructure? E-courts phase 3 at the NJDG. And the frontier part. What is the frontier part? The draft AI regulations in consultation as of this revision. So get the drafts status right. Quote human primacy and connected efficiency to Article 21. That is the whole scene in one breath. So this is regarding working judiciary. In this working judiciary, we discussed dependency of court cases and digitization and a draft AI policy. With this pendency 4.5 cr 5 crore 4.5 crore 250 HC judge vacancies and infrastructure e-courts phase 3, and then comes to the counterweight part, the digital justice divide and e-filing and virtual hearing, presuming connectivity. Then comes to the AI part, AI codes published, then architecture part. In this architecture part, five principles: human primacy, transparency, accountability, data protection, and judicial independence. So this is all regarding about this working judiciary pendency and the digitization and the draft AI part. Then we are moving to scene number 40, that is 130th Amendment Bill, removal by detention. What is this 130th Amendment Bill? Extends Chapter 6, Scene 12 Parliament and Chapter 4, Scene 10 basic structure and pairs deliberately with Scenes 28. What happened? On 20th August 2025, the Union Home Minister introduced the Constitution 130th Amendment Bill 2025 in the Lok Sabha amid vociferous opposition protest, along with two companion bills, the Government of Union Territories Amendment Bill 2025 for Puducherry and Jammu and Kashmir Reorganization Amendment Bill 2025. The package amends Article 75, 164 and 239 AA to create something Indian constitutional law has never had. That is removal from ministerial office by detention. What is that removal from ministerial office by detention? The mechanism precisely: a minister accused of an offense punishable with imprisonment of 5 years or more, who has been arrested and detained in a custody for 30 consecutive days, is to be removed by the president or governor on the advice of the prime minister or chief minister given on the 31st day. Or if no such advice comes, automatically on the 31st day, for a prime minister or chief minister, the bill requires resignation by the 31st consecutive day of custody, failing which they cease to hold office the day after. And note the detail that sharpens every critique. The removed minister is eligible for reappointment upon release. What is this? So the status, and get it exactly right. What is this? The bills were referred to a joint parliamentary committee chaired by Aparajita Sarangi, which as of the revision is expected to adopt its report on 17th July 2026, with the government reportedly planning to move the bills to the monsoon session beginning 20th July. So retaining the core removal clause here. What is this? What is the clause here? But carries in 28's arithmetic with you. What is the 28th scene? What is that arithmetic with you? This is a constitutional amendment. It needs two-thirds special majority. And the government demonstrably lacked that number in April. So this is not settled law. So it is a pending constitutional amendment whose fate is genuinely uncertain. And writing it as either enacted or doomed losses marks equally. So now the constitutional debate here, both sides at full strength. The government's rationale what? There is today no provision anywhere constitutional or statutory for removing a minister who is arrested and jailed. Disqualification under section 8 of the RPA 1915 operates only upon conviction. And a minister governing from custody, the government argues, towards constitutional morality and good governance. The unspoken backdrop being a chief minister who ran a government from jail for months without resigning. So the objections and the PRS analysis gives you ready four-part structure. What is that analysis and what are the four-part structure? The bills may violate four features of the basic structure. That is parliamentary democracy. What is the parliamentary democracy? An elected government removal by investigate agencies rather than the House of Confidence. Then separation of powers. Removal triggered by executive arrest with no judicial finding of guilt anywhere in the chain. How it is possible? Comes to the federalism part. A state police force could, in principle, arrest and thereby unseat the prime minister. Central agencies could unseat a chief minister. And the comes to the part rule of law. 30 days of custody involves no judicial assessment of likely guilt. So the bill converts the presumption of innocence into removal by accusation. So Indian law currently disqualifies legislators on conviction. This bills removes ministers on custody, a shift from the conviction based to a custody based system with all agency weaponization risk that implies. And on the rule of law objection with its strongest judicial citation is the Supreme Court's November 2024 bulldozer demolitions judgment scene number 48 had already held in terms that punitive consequences imposed by executive action and mere accusation without adjudication violate the separation of powers. A removal by custody mechanism must answer that the same doctrine. So comes to the answer writing, but the Constitution 130th Amendment Bill 2025 seeks to advance constitutional morality but may endanger constitutional structure. Critically examine. This is the question. What should be the answer? Answer start with states the bill's mechanism precisely. Then what you have to write? The 5-year offense threshold, then the 30-day trigger, the automatic operation, the reappointment clause, then presents the governance from jail rationally fairly, then deploys the four basic structure objections as its analytical spine, then notes the conviction versus custody anomaly against the RPA, and closes with on the live status, that is a JPC report imminent and a special majority still unsecured, and echoing scene 28, the amending powers practical limits once again display. So comes to the summarized party. What is that summarize? What is the summary of this entire issue? This is basic structures next to battlefield arriving in real time. Know the mechanism, the four objections, the RPA contrast, and the pending status, and watch the monsoon session because the scene may acquire its ending while you revise. So then we are moving to next part, that is 16th Finance Commission, the fiscal half of the federalism bargain. This is the extends chapter 5th, scene number 11, federalism, and gives the 73rd and 74th amendment block in current affairs anchor. Comes to this part, every federalism scene so far has been about power and seats. This one is about money, and no GS2 paper cycle passes without fiscal federalism. So treat this as mandatory, not optional. Finance Commission is a constitutional body under Article 280, constituted by the President every 5 years, whose recommendations tabled in Parliament with an explanatory memorandum under Article 218 are advisory in form but almost invariably accepted. An advisory in form decisive in effective pattern you have already met in scene 26 Article 143 discussion, because the 16th Finance Commission, chaired by Dr. Aravind Panagaria, submitted its report to the President on 17th November 2025, and it was tabled in Parliament on 1st February 2026 alongside the Union Budget. For the award period 2026-27 to 2030-31, so the government accepted the headline recommendation no. Five holdings cold. What are the five holdings? One is vertical devolution retained at 41% of the divisible pool, unchanged from the 15th Finance Commission, despite states collectively demanding 50%, and carry the standing critique that the divisible pool itself excludes cesses and surcharges. That is the thing here, one vertical devolution recording. Then so the effective state share of gross central taxes is well below the headline number. So comes to the second one, the horizontal formula was meaningfully redesigned. What is that? A new criteria. States contribution to GDP enters with a 10% weight, rewarding economic output for the first time. Income is instance is now measured against the average per capita GSTP of the top three large states, and demographic performance has been redefined from fertility rates to population growth between 1971 and 2011, a direct descendant of the same 1917 freeze logic you met in scene 28. So third one, grants worth 9.47 lakh crore, of which 8 lakh crore goes to the local bodies, and 4.4 lakh crore rural, and 3.6 lakh crore urban, with urban share deliberately raised in recognition of projected urbanization, and over 2 lakh crore to disaster management, while revenue deficit grants, sector specific grants, and state specific grants have all been discontinued. Comes to the fourth part, and this is your only live 73rd and 74th anchor. It is entire part, so you have to use it. All local body grants are conditional on three entry criteria. What is that? Local bodies duly constituted as the constitution requires, provisional and audited accounts publicly disclosed, and state finance commissions constituted on time, with grants split 80% and basic and 20% performance based. So the finance commission, in other words, is now doing what 3 decades of exertion could not, making decentralization compliance a condition of money. So fiscal discipline package, state fiscal deficits capped of 3% of GSDP, off budgets borrowings to be discontinued and counted as debit. So a pointed warning against the explosive growth of unconditional cash transfer schemes, and a recommended review of 308 inactive state public sector enterprises. And the conditional grants lever has a judicial twin from the same window, which converts your 73rd and 74th Amendment coverage from one anchor into two. In Rahul Rameshwag versus State of Maharashtra, the Supreme Court confronted the fact that elections to nearly 2,500 Maharashtra local bodies, including the country's richest municipal corporation, had been pending since 2022. The bodies run by appointed administrators, initially over the OBC triple test data question. On 6th May 2025, the court directed the State Election Commission to notify the polls within 4 weeks and complete them within 4 months, invoking Articles 243E and 243U's 5-year mandate. When September arrived notification, without notification, a bench of Justice Suryakant and Bagchi rejected the Commission's excuses delimitation, staff EVM procurement as neither new nor unforeseen, and fixed an outer limit of 31 January 2026, under which the long stalled polls finally began moving in phases from December 2025. The constitution point of your answer is Part 9 and Part 9A made local government mandatory, not optional. And this cycle supplied both the physical enforcement of that mandate and the judicial enforcement of decentralization. In other words, is now being compelled from two directions at once. The Finance Commission's entry conditions, the work directions. So the analytical framing commentators have converged on which you can quote. What is that quote? A shift from entitlement based transfers to compliance driven and performance driven physical federalism. This is the shift from entitlement based transfers to compliance driven and performance driven fiscal federalism. That is physical federalism. And the critic writes itself along the same axis. Performance conditions and tied grants improve accountability but shrink state fiscal autonomy. The GDP contribution weight rewards already industrialized states. And the equity question is whether structurally weaker and hill states lost ground replace in physical form exactly the southern states' anxiety that's seen 28 president seats. CM federal bargain, two currencies at representation and revenue. Comes to the answer part. The recommendations of the 16th Finance Commission mark a shift from entitlement based to performance based fiscal federalism. Critically evaluate. Answer states the Article 280 281 framework and the 41% retention and the cess charges caveat, and then new GDP contribution criteria and a redefined demographic performance, and then conditional local body grants as a decentralization lever, and then discontinued revenue deficit grants, and then ways efficiency and accountability gains against autonomy and equity costs, then closing with the scene 28 cross references like the physical and territorial half of the federal bargain are under renegotiation simultaneously, and a mature answer names the convergence. And one scene here, three syllabus boxes ticked. What is that? The Article 280 fiscal federalism, the center state resolution resource debate, and through the conditional local body grants. The only current affairs handles this cycle offers on Panchayati Raj and urban local government. Do not walk into mains 2026 without it. So this is all regarding about 16th Finance Commission, the fiscal federal bargain. So what is the Article 280 body and what is the five holdings? The holdings is important. Then this is all regarding all this is all regarding the 16th Finance Commission. And next we are going to discuss census 2027 and the caste count, the data that unlocks everything. This is that is going to discuss in the next class. Thank you.